And the school board held a closed session, and there were sort of crowds gathering outside. Now, the Times Free Press says that Welch, who's a member of the school board, told a group that was gathered during the scheduled public meeting on Wednesday that the board could not talk about the case at the request of law enforcement. Bennett said that after the meeting, he also advises the board in a private executive session not to discuss the case. He said that any public comment could hurt the ongoing criminal investigations in both Sevier and Hamilton counties. Bennett said that he was told by the assistant district attorney in Sevier County that the judge ordered people not to talk about this case. Now, that turned out to not be true. He indicated that there was a gag order on this particular case. There was not. There was no statement of any sort that we can find regarding a gag order about this case coming from Sevier County. Well, then later, Bennett clarified on Thursday of that week, saying that he had not spoken with the judge who they said issued a gag order, nor had he seen an official order from any judge, which is where you would receive a gag order from, is from a judge. He did speak to law enforcement in Sevier County, who advised that school officials shouldn't discuss the case, saying, until I hear otherwise from the assistant district attorney, I have to assume that the investigation is not complete, and the judge has instructed everybody connected with this case not to say anything, Bennett said. So this is not a gag order. There's a very, very big difference between law enforcement asking you nicely not to say something and an actual gag order from a judge. A gag order would be a legal order to not say anything about a case. And then police officers asking you nicely to not say anything about the case is an entirely different matter. And because this is a school board meeting, meaning it's a public event, it's a matter of public record, that really can't happen. There's now a conflict with sunshine law, is what it's called, which sort of demands openness at any sort of public meeting. So there's now a possible violation of sunshine law due to this. Now, school board member Rhonda Thurman gave some interesting comments about the situation as a whole, saying, have we gotten to this point? School board member Rhonda Thurman asked in an interview, according to Heavy.com, with the newspaper TFP, saying, it's heart-wrenching to me. This boy could have died. I'm not holding the team responsible for the actions of three. I'm holding the whole team responsible because somebody did not come to this boy's defense. Now, this is where we start to get to the issue of a possible culture of violence within the school system, or at least within the athletic system in the school. 3 adults now have been charged in an alleged team hazing involving the Ottawa High School boys basketball team. This is coming from WRCB. More charges may emerge, and the Hamilton County Chief Prosecutor is now looking into whether there's an ingrained culture of violence there among the basketball and football teams. So now there's a full-blown investigation into Ottawa High School about whether or not there is a culture of violence, is what they're calling it, an ingrained culture of violence at the Ottawa basketball team. Basketball coach Andre Montgomery, sometimes called Tank, and the assistant coach Carl Williams and the Ottawa athletic director Allard J. Nyadli are now accused of failing to report child sexual abuse for 4 victims who play on the boys' team, according to the Hamilton County District Attorney General's office. Now, we've gotten reports, and I've read some reports in just different media, saying that this was all reported to the day after. After the incident happened, this was what happened was told to Rick Smith the day after. Now, that's not a notification of law enforcement. That's a notification of your higher up within the school system. To sort of make just put things into context, think of if you're a Boy Scout leader and something happens within your Boy Scout troop that's of this manner, and instead of going to law enforcement immediately, you talk to your supervisor at Boy Scouts of America National instead of going to law enforcement. That then would be a violation of Tennessee law, which states you must notify law enforcement as soon as you hear about it. Otherwise, now you're in violation of state law. That's a state accusation. According to the DA, that's the district attorney, Neil Pinkston's office, all 4 victims told investigators that they were beaten with pool cues. Now, that's another interesting statement. This is separate from the charges, by the way. Now we're hearing about 4 victims in this case beaten with pool cues while in Gatlinburg last month. And that just came out as of possibly last night. We're hearing about 4 victims, not 1, being beaten with pool cues. This leads to think, and we have David Tulis with us here from the David Tulis Show, which is on from 9 to 11, who's on with us.
Well, what does beaten with pool cues mean? The listener wants to know.
That's
beaten
a good
with
question.
And having it put into your rear end are different acts.
This would indicate to me, now again, I'm not there, and this is only speculation, but this would indicate to me that those 2 things happen. Because obviously this, as far as we know, the victim was treated for internal injuries. to the rectum and to the bladder, which wouldn't happen from superficial damage done with a beating of a pool cue. So I've seen law enforcement statements saying that there was this and there was the inclusion as well as the sodomy. And so and I have something else here that plays into this, a statement from different students and a statement from different, I think it was the victim who we keep hearing about. I don't mean that in a negative way. I'm just saying that this is the victim whom we are usually hearing from, that there actually is something that they're called beating ins or a beat in. Here it is from WRCB. The primary victim's family also says that 2 of the older students were physically involved in the attack, while a third took video of the incident with a cell phone. Now, that's very important, too, is that WRCB got information that there was a video of this incident. Now, that's giant for the case. Obviously, if there is video of it, it could be open and shut right there as soon as it goes to trial, if you have actual video images of it happening. But then you have to go by how clear is it? Was it a bad cell phone video? Is it a vertical video? You can't see anything, all blurry. We don't know yet. And we'll never see the video, I'm sure. We outsiders. The younger students reportedly told investigators that older students told them they have to be beaten in and that it is a ritual at Ottawa High School. The victim says such incidents happen at school as well, in the locker room with the lights turned off. The younger students say that they are told by older students it must be done. And they also say that these actions predate Coach Andre Montgomery, who has been on the coaching staff for 3 years, including 2 as head coach. They reportedly told investigators that Montgomery has not personally witnessed these beat-ins. But then this raises the question, is he aware of these beat-ins? If you're, of course, the head coach of a high school basketball team and there's something like this that goes on, and obviously most of the people in the athletic system as students seem to be aware of it, how is then the head coach not? Is a question that I've been seeing on social media. I've seen quite a lot of that.
Well, you're making a distinction here between private acts of violence, Russell, and those that are organized or quasi-organized or cultural. A team abuse when you're beaten in, that is something that in that culture of the go-get-em team members, that's organized. But there are reports, for example, in yesterday's Chattanooga, of a mom telling about her son 4 years ago, almost exactly 4 years ago, on a school bus, age 13. Her name is Tanya McBriar, and she leads the story by Claire Henley Miller at Chattanooga.com about how this boy was beaten by a colleague, a fellow student, and had $20,000 in medical bills from an assault. And she accuses Superintendent Rick Smith, saying, "You failed my child."
And we have, and this seems to be a thing that is recurring. Where is it something that is an organized event that's done by a certain group within the school? Is it the athletic team? Was that kid in this particular instance involved in the athletic team? Any sort of athletic activities? There's all sorts of questions that are raised by that where there's really not an answer. And that's where the Attorney General's investigation comes in Hamilton County, because now there is an investigation into whether or not there's they're calling it ingrained culture of violence within Ottawa High School.
Well, I think Mrs. McBriar's distress was of the private, personal variety and not the organized.
I see. So there's maybe perhaps a duality going on there, where there are private instances and there are as well institutionalized or organized instances of violence.
Well, Russell, the lead on yesterday's Times Free Press, the top story on A1 is school hazing policies not in compliance. How is that becoming the story now?
Well, now we have issues of state laws regarding cyberbullying. You have state law regarding, and sometimes even federal law regarding hazing. And there are laws requiring compliance about procedures where you would handle that and how school districts are supposed to handle that. And I think there's also an issue with school resource officers, SROs, who are supposed to handle issues like this as well. So it sort of calls into question, is there not any sort of oversight of students saying, this is obviously hazing, something needs to be done about it? Are they subjectively unaware what exactly is happening within the Hamilton County school system?
Well, the General Assembly is far away, and it sort of lobs laws to every school district as if a mortar firing a shell, hoping for the best. And so the laws that came out of the General Assembly in past years, Title 49, the education book, it's one volume, require districts to do certain things so that the members of the General Assembly, our representatives, right, can be assured that young people are not being harassed and hounded as some of those have been at Ottawa. For example, a district shall have a statement prohibiting harassment, intimidation, bullying, or cyberbullying according to the statute. Well, in other words, there has to be something in writing, some sentences in writing that are kind of seen as a kind of bulwark protecting these students from internal and external harassment in the system.
And that could be flyers on walls or
well,
anything.
That would be, the statute doesn't require that, but that could be an outgrowth of a desire to obey the rule. Now, what's the one part of the statute that seems to be, as of today, not being honored by Hamilton County school system?
That would be the reporting aspect of it, where you have here a procedure for reporting an act of harassment, intimidation, bullying, or cyberbullying, including a provision that permits a person to report an act of harassment, intimidation, bullying, or cyberbullying anonymously. That's the key word. So nothing in this section may be construed to permit a formal disciplinary action solely on the basis of an anonymous report. So there has to be an investigation done after the anonymous report is made.
Now, of course, that the fact that you can have snitching in the school system is a very dark prospect in my mind, because what you have is a very, very institutional setting. And think of people who have grievances against other people as students, right? A senior has a grievance against another senior who's beating him out on math tests or translations in German, right, in the German class. And so, having a vicious heart, he makes an anonymous complaint, and that victim can be hounded for the rest of the school year, and maybe be so distressed by it that he's not going to remember his German verbs correctly and make it be in the class.
Heaven forbid. Of course, there is a procedure in place to somewhat help to prevent that, saying that there has to be a disciplinary action based solely. There can't be one based solely on the basis of an anonymous report. So this would,
but think if you have that system, which is not in place in Hamilton County, maybe to its credit, right? Maybe outside the law, but maybe to its credit, you don't have this anonymous system where people who are already hostile. We see there's a lot of hostility in that system among its inmates. We don't have a system for abusing someone else by a false report. I think whenever you have a system so large that you have to have that for surveillance, you've got internal problems that are of grievous order.
I want to get into something else too that has not really been addressed too much in, I don't know how to call it, I guess, mainstream reporting. That sounds kind of pretentious.
Yeah, we're mainstream, aren't we, Russell?
We are kind of, I guess. I don't feel mainstream, but sometimes you have to acknowledge what you are. No, but I've seen a lot of reports, I'll say other outlets. I've not really seen a whole lot about the social media aspect, and I think that does play a huge part of it that's being downplayed or just not talked about at all, because it's not really very well understood by other news media outlets. I'm not bashing them. I'm just saying that's the fact of the matter.
Well, how is social media a main part of the story, Russell?
That's a good question. There's so much that happens on social media, and it makes things happen so quickly. Think about how quickly this story has developed. December the 22nd is when the incident happened. What day is it now? It's the 14th or the 15th, I think, of January. It's the 15th of January today. That's a very quick turnaround time, especially for charges to be pressed against 3 people now in the school system. Now, there's not an indictment. That's something that we were talking about that needs to be made clear. There's no indictment. There's not an arrest. There's a summons for them to go to court next Thursday.
That's Judge Rob Filial's juvenile court Thursday. The 3 who are accused have to appear before him. So this is kind of pre. If there's an indictment, they should not accept going to trial without an indictment. And I think it could be passed off to the grand jury for the people to ratify the accusations.
We're going to get sort of more into the minutia and the mechanics of these trials here in just a few seconds on Hot News Talk Radio AM 1240. This is a special report, Hot News Talk Radio AM 1240, and we're always here at hotnewstalkradio.com as well. Now, the mechanism of the juvenile court is something that needs to be clarified, because I'll be frank, I'm not sure how this is going to work. If they go to juvenile court, is that going to be part of public record? Because juvenile court works differently from major courts would.
Right. Juvenile court is a secret court, and that is to protect the family members, to protect children who are involved in ostensible criminal acts. So there's no record of their having been involved in crimes. It is to protect the prospect of a child so that he does not have a record through age 18 or so.
And that's something, again, where the social media comes into play, because we're talking about a charge, or we're talking about a court case where we in media, we're not going to get any information, most likely, out of these court documents. There might be some open records like there were before, where we were seeing that, where the names got released of the accused in this case of the 3 freshmen, or the 3 seniors and 1 sophomore, I'm wanting to say, who were accused or are accused now, are going to be going to juvenile court soon. They're out on bond as far as we know. Where we didn't really get a whole lot of information out of that. We're not going to be able to just go to the court and have cameras and audio recorders and draw sketches. We're not going to be able to do that, even though these are adults being who are going to be going to court. We're not going to be able to do that. That's where the social media comes into play, because we're seeing a lot now of details coming out from people who are involved in this, right? People who are in Ottawa, high school people, high school kids. I know quite a few. I'm close to that age range myself. High school kids are very involved in social media. You can be checking all the news. You can be tweeting about it. You can be Facebook updates about it while you're at the dinner table. You shouldn't, but you can. There's all sorts of information coming out from the inside, so to speak, of kids who are posting on social media and adults who are angry who are posting on social media. We're seeing images. We're seeing posts saying rallying for support of the coach who was just charged. We're seeing all sorts of things. And by the way, that did happen, I think, 2 days ago. There was in Ottawa a rally with different students at Ottawa High School who are rallying support behind the coach who's just been charged. So there's a flip side to everything, right? There's another side to this where some are saying that the coach is innocent, or at least not guilty of what he's being accused of.
Well, many young people, and in fact many adults, put a lot of stock in social media. But the problem with social media is that it's very postmodern. Your identity, your purpose, your soul, your person is fluid, it's temporary, as social media is. Everything is provisional, everything is just now, whether you have the number of likes you have or dislikes, whether you have followers. These are all things that are your self-estimation, your perception of yourself as a young student is built or destroyed by this fluid series of platforms on which you have your being and your identity. People are not somehow rooted in themselves anymore. They're not connected to their souls, and so their character, their outlook is put aloft in this very, I would say, vacuous area.
It is, yeah. I mean, I would agree to somewhat of an extent that it is a very narcissistic sort of system with social media.
Everything is provisional.
It's by design.
Media.
Sure.
Right.
But what we're talking about here, and that might be another show. What we're talking about here is the news aspect of the social media, where we are getting quite a lot of good information.
Right. Parents can organize quickly.
Exactly. And that's another big thing, is we've seen that petition, the change.org petition, asking for the resignation of both the coach and of Rick Smith, the county school superintendent, Rick Smith, who gave, I'm thinking now, 2 press conferences. The first press conference that I saw was live at 3:00. And he did not give, not today, this week sometime, and he didn't accept any questions from the audience. It was just addressing concerns, I think is how he would put it, deep concerns or strong condemnations for whatever happened. But it was sort of a very impersonal kind of press conference, the one we saw where Rick Smith was giving his statements. And that's always going to be how it is when we're talking about a school board, when we're talking about county mechanisms or state or federal. They're always going to be impersonal. And it did seem to be a little bit more personal, although it was very impersonal. He did sort of speak, I guess, from the bottom of his heart, saying, I've been in the school system for forever. We're doing the best we can. But something that he addressed that was very important and was very relevant to the listener, perhaps, who was calling for the resignation of Rick Smith. He said in that press conference, I have no intention of resigning, haven't even thought about it. So Rick Smith, as far as we know so far, if he's being truthful about that, and I have no reason to think he isn't, is not even thinking about resigning. There might be some recall, but he's not thinking about resigning now.
I think this story tells a lot about our interest in forms and outward words. The statute that discusses the need for school districts, LEAs as they're called, local education area, LEA, they're supposed to have a lot of writing, much pages and pages of type. If they had, say Hamilton County had in fact all the type, would it have stopped things? Well, probably not. But somehow we think that if it only had, then this wouldn't have happened. We're somehow able to blame the lack of a lawyer saying, well, you, the board members, need to write these statements. For example, one of the statements that's required is one that prohibits reprisal or retaliation against any person who reports an act of harassment, bullying, or so on, and stating the consequences and appropriate remedial action for a person who engages in such reprisal or retaliation. Well, in other words, when you have using the secret portal that it doesn't exist, but let's say it existed, the secret tattletale snitch portal that the county is supposed to have in the school system. If you abuse that, what are the consequences? Well, there's supposed to be a description of what happens to the student. Again, not written by the state, but written by the board and its attorney. What the consequence is for a student who abuses that portal by slandering someone. Well, maybe that statement is not there. Well, evidently it's not there because the portal does not exist, which would be the basis of this follow-up lines of type. But does that really matter? I wonder. That is where the story is going. What is the form, and how close? What are the forms that the county has written, and how close do they hew to the Tennessee code?
Well, that's another good point too that I was just thinking of too, is whenever we have a disaster of any sort, and some would, and I couldn't disagree with them, say this is kind of a disaster, what happened, especially for the victim, a horrible thing what happened to the victim, the one that we know the most about, who was raped with the pool cue. Obviously, that's sort of is an awful thing to happen. As far as we know, by the way, he has been released from the hospital after 8 days, I think, being involved or being in the hospital. He's been having nightmares. That's what I've heard from statements from the victim family. Having nightmares, doesn't feel comfortable being alone. Possibly is worrying about retaliation, which was, by the way, something that we had heard about before, that the victim had tried to report this perhaps culture of violence, as it's been called, to the school system, or at least to a teacher, or maybe even to the coach, and was worrying about retaliation. And guess what? Then this happens. So it does make you wonder. And again, there's been a lot of speculation about that. Was this act because of retaliation? Because it does seem to be what happened to him was a lot
counter
more
retaliatory act.
Right. It's a retaliation to a retaliation. What happened to him, if this happened at the same time as the beating with the pool cues we heard about 4 other victims, seems to be a lot more obviously severe than what happened to the others. So was he singled out is another question. And that seems to be indicated by what happened, but we don't know for sure. Again, there's not a whole lot that we know for sure, because this is a very sensitive case and it does involve juveniles. So there's probably, and I hate to say it, especially as a journalist, but there's a lot we're not going to know, possibly ever, about this case.
Well, the law defines bullying and cyberbullying specifically as harassment, intimidation, or bullying. And it says that it causes emotional distress to a student or creates a, quote, hostile educational environment. And these things, of course, are forbidden. But how can people who run school systems think that will make any difference to children in their domain up to age 18 years old? Some of them, if the instructional system itself is highly materialistic, highly impersonal, favoring not personal responsibility, entrepreneurship, and care for the others, as you would find in a more Christian setting. You have an impersonal machine, an educational factory, and the students are just charges in it, and they're not really given the basis for right, moral, and good actions, what a Christian would call a godly way of living. That's not really given to them. And in fact, the means to even borrow from Christianity is often denied these people as a matter of course in their coursework and in their dealings with the state and the state's actors, the teachers and staffers on the payroll.
Well, I want to get into something too, and that's very good. But I want to get into something too that I was sort of trying to get at before, which is the whole "how could this happen" sort of thing, where we all say, "How could this happen?" Obviously, what happened was a very sort of primal and very aggressive, right? That's probably a great way to describe it. It's just very aggressive and not necessarily inhuman, because obviously humans are capable of doing this and have many times before. But this is still a very it's an awful thing. And now the next logical response is going to be, what can we do now to prevent this from happening again? Because that's always the question that gets asked whenever there's a tragedy like this one, whether it be mass shootings or poisonings or anything like that. We always want to ask the question, how can this be prevented? So how then, just looking at the mechanism and looking at sort of the cold mechanicalness of the school systems and the state regulations on school systems, it looks like, to me anyway, it looks like all that's necessary to prevent this on a legal basis was already there. It's just that the law was sort of ignored by, at least it appears that way, was ignored by people in charge. And that does seem to be the indication when you look at what's going on here.
And a question I have, Russell, our news director here at AM 1240 Hot News Talk Radio, is to what extent is this case a sexual case? Is it sexual? Is it sodomy that this young man was abused? Is it of a sexual nature, or is it simply of a physical nature? It was opportune to abuse him that way. There were pool cues handy, and hey, let's just use this pool cue and ram it up this young man's rear end, not because we're homosexuals, but because we have him and we've got him and we're going to make him pay. Is it sexual in nature, or is it simply abusive and violent in nature?
That'll probably, well, because the charge is aggravated rape, I would assume that the sexual is what they have in mind. At least the prosecutor.
In all appearances.
In all appearances, it is sexual in nature because of the charge of aggravated rape against, and especially it's aggravated rape. And that's something that needs to be taken into account too, because there's a difference between aggravated and just the act of rape. Aggravated meaning there's a little bit more violence involved, right. I suppose.
Ottawa high school boys can be homosexuals, and no doubt there are homosexuals who are practicing sodomites. There's a story, just by the way, about 2 teens in DeKalb County, Georgia, who are being charged with sodomy in an investigation. This is from the Chattanooga Times-Free Press, Alabama, rather. And there's a case against 2 young men, 19 and 18, from Fort Payne. And there's a note of thanks from the sheriff, who says, "We would like to thank the Child Advocacy Center for their help in this case." So there are these are homosexual acts, but there's a charge of sodomy when there's a lack of consent or a lack of a sexual interest on the part of the recipient of the instrument.
Yeah, and it does make you wonder, because that is sort of an interesting charge, aggravated rape. Obviously, things will be. Well, they won't be revealed to us, but things will be revealed to the victim and to law enforcement during the course of the trial. There's going to be defense and there's going to be prosecution, just like any other trial. So I can imagine there's going to be arguments that this was not aggravated rape, this was something else, or what have you. It can't be, you can't charge them with this because it wasn't this, so then you have to charge them with something else and then go to that trial because you can't have double jeopardy. There's going to be all sorts of legal mumbo jumbo going around. There's going to be all sorts of legal problems. This is a very complex case because there aren't a whole lot of details. Now, the video, again, I want to point out to the listener that there, according to the TFP and WRCB and many other news sources, there's a video that was taken of the incident in occurrence. So that's very important to note. This is going to help out the prosecution quite a lot. I can't imagine it's going to do very much for the defense. This is something, by the way, where, again, the rise of technology helps out a case like this, because let's be frank, something like this could have happened in 1952, right? This could have happened in 1952. This is not, pool cues existed then, aggravated rape existed then, ill intentions existed then, and I'm sure bad kids existed then too. Not that I was around, but so the fact that there was a video of it could not have happened 10 years ago. The fact that there's a video of it probably couldn't have happened even possibly 5 years ago. The cell phone being so affordable, and again, that's sort of the social media thing, is the cell phone being so affordable, the technology just being there in everyone's. I've got one, you've got one now. We all have one. So this adds
why
to.
Why did the young man take the photograph? He wasn't taking the video of it because he was opposing it and wanting to show something wrong that he was going to use as evidence. No, it was part of the celebration. It was part of the exciting moment that we have where we're going to show this student. I think part of it because it was complicit with the act itself. It was part of the celebration of youth and vigor, perhaps.
Well, I want to say that perhaps humiliation would be the better word to use. The video being taken of it now, you sort of have, because I've not been in that situation, but I've been in similar situations where, we're going to do this and that, and we're going to take a video. Well, my friends will see
and you'll never live it down.
You'll never live it down, exactly. And I wonder if it escalated, if it was something, I don't want to say more innocent, but if it was something less aggravated than this and escalated to what it was, and all the while the camera's still figuratively rolling.
Yeah, we're going to take this as if they were saying, these young men, well, we're going to take this boy's notches among his social peers down a notch or two by doing this humiliation, and we won't hear from him for a while, and then when he's gained his self-respect, he'll come back and want to be part of our club.
Right, he'll be cool now. I guess
he'll be cool. That's right. He'll have learned his lesson, and he's now properly chastened. Allowed to be in our inner circle.
Right. I mean, frats do stuff like this, not stuff like this, but frats do similar
in the
activities.
same spirit.
In the same spirit, right. Where, how many shots can you take before you burst? That sort of thing. It's a little bit less aggravated than obviously what we have going on here. But that sort of spirit, right, exactly. The intent sort of is a little bit similar, where perhaps it started out not as aggravated and became what it was. Again, we don't know. This is pure speculation.
There was a forum yesterday, and it's being reported on by Claire Henley Miller at Chattanooga.com. And on the jump page, there's a reference to Jennifer Woods, who spoke to the assembled host of parents and officials. And she's a child advocate and a former county teacher of 34 years. And she says that she would like to see a better partnership between county schools and the juvenile court. She says, it takes a village to raise a child. We are the village of Hamilton County. If we lose one child, that's one too many. And she encourages the board to take this occasion and make it a positive system. But what I noticed in seeing the photographs of that hearing, Russell Stroud, our news director here at AM 1240 Hot News Talk Radio, is the distinction between the people and those in authority. Those in authority sit on a high banister behind a wall. And if you notice the photographs, those who wish to speak, as if they were subjects, humble petitioners come to the mic and speak across a vast void of carpet to those heads there behind that wall, those who hold authority. So there is clearly the people who are ostensibly being served by public education are not their own masters. They don't control their own destiny educationally. It's all controlled by the state, which stands behind those elected heads there at the school board.
Well, something that plays into that point too is something that I was sort of hinting at before, where we have that sort of attitude of, and we get it especially in Ringgold, where I'm from, of good old boyness, right? Like you sort of get that thing where this guy knows this guy knows this guy knows this guy, and they've been in office for 20 years, right? These guys have been in office longer than half of us have been alive, than all the kids in the school have been alive, possibly combined. They've been in the system for a long time. And now, again, with Facebook and with Twitter, there's sort of that attitude where people can get together and say, you're not getting away with this. This is not getting swept under the rug. We're going to call you out. We're going to demand answers, and we're going to do this to the best of our abilities now through organization on social media. We saw a lot of that with this case. There was, again, that change.org petition to have Superintendent Rick Smith resign. And I'm not making any accusations towards anybody. I'm saying this happened. There was a petition for Superintendent Rick Smith to resign. So there's obviously quite a lot of organization on social media. There's probably a Facebook group that organizes behind this as well. There's lots of organizations and just angry people on social media who want to see justice.
So the news summary is that Coach Andre Montgomery, who was held without pay and he was initially assigned to a desk job, not in contact with children,
non-teaching position,
and now has apparently been kicked off the payroll for until trial. There's an assistant coach, Carl Williams, and athletic director, Jesse Neadley. They're all being charged, not by indictment, not by the people yet, but by Neil Pinkston. He is the district attorney, and there will be a meeting at the Bar of Justice in juvenile court, which apparently has subject matter jurisdiction, since the victim and the participants in this crime was reported as a crime are juveniles in the state's custody. Now, Neil Pinkston is elected, and he is he of course in a way he doesn't represent the people, though they elect him. He represents the state, though he is elected. So he has one eye on the people and what they suggest to him by their demonstrations and words they expect. But also he's a servant of the state and is looking at law and trying to look strictly at what does the law require. And the charges against these men, at least provisionally in the summons, are that they failed to report what they knew were crimes. And that is a crime in Tennessee, to not report something to the proper authority when you see abuse, sexual abuse or other of a child.
And of note, too, is that this is a legal first for Hamilton County. At least that's the speculation, is that this might actually be a legal first for Hamilton County. And something we were talking about before that's interesting, too, is that this is the charge is failure to report child sexual abuse, which is a Class A misdemeanor, but we're not clear on the penalties. So this could be, I guess, in this case, and again, I'm not a legal expert, the penalty would be set by the judge, would it not be? And there'd be minimum parameters that, it has to be above this. So the penalty be set by the judge, would it not be?
Well, I would say the judge at the other end of the trial. There has to be a trial,
right? And
if these defendants are men of courage and have some good advice, they will demand to be indicted. They won't have. I would say that they may be. I would waive the court. I would say, well, I'd rather be in a court of record, not here. I don't believe that that juvenile court is a court of record. It's a kind of a corporation court that has very limited jurisdiction, but it has huge power. The juvenile courts have gigantic power in our state, and that's where families are broken up, where Child Protective Services harasses families, seizes children from families who have an odd habit of doing things, or maybe are reported on, and families are broken up in juvenile court. That's where it occurs in legal, maybe not rightly, but legally it happens there. And if these defendants are cautious, they will say, I don't want anything done here. I want it in a court of record. And to have a court of record and to have access, they have to exercise the right to an indictment. You'd say, our listener, well, that sounds terrible to be indicted. Well, actually, being indicted is your defense, because if you're indicted, the people have at least heard one side. They've heard the state's argument, the state's evidence, the state's proofs, as far as the state has it at that point. And the question they answer is there enough material for a trial of these three school officials? Is there enough in the accusations to warrant the people hearing the law and the facts and judging the law, I would say, and the facts. Of course, the establishment position is a jury in the case of these three men will judge only the facts.
Would you say that this
will be doing at least that?
Sorry, would you say that this almost appears to be symbolic in a sense where if they, it seems to me, and you know, I'm not very connected. I'll put it, you're more connected than I am. It seems to me that this is almost a symbolic move where, okay, you know, the people want something, so we'll give them this. It sort of seems that way to me. It seems like there's sort of perhaps, I don't want to say not enough being done, but it seems like this is done very reluctantly. And it may be more of a.
Well, didn't we just say, Russell, that the movement by the district attorney Neil Pinkston is quite rapid? Is his movement rapid or reluctant to bring these accusations to the juvenile court?
I think it seems very quick. The way it happened, and if you look at the timeline, obviously the event happened on December the 22nd, right? So then there has to be, obviously there's an investigation. There are accusations being made. There are already charges pressed against the juveniles involved within the school system. This is part of the juvenile court system. So when the alleged rape happens, then you have the juveniles who are being accused now. Then this comes out, I'm wanting to say 2 days ago or yesterday, about the three adults being charged. And this is, of course, it's a summons. There's not an actual arrest. They're not indicted at this point. But there seems to be, it seems like this happens very quickly, but perhaps the way it's done, I don't know, there's just something about it that seems kind of strange to me, the way this whole thing is being handled. But to be fair, and as fair as I can be, I suppose, this is a very weird case for everyone involved, I'm sure, because we're talking about a sort of a tight-knit community here in Chattanooga, especially. It's very tight-knit. It seems like everybody who's elected in a position knows the other person. You know, I'm sure Superintendent Rick Smith has perhaps shake hands with Neil Pinkston at some point, right? It seems like there's a lot of connection going on there.
Well, the Chattanoogan Russell Stroud, our news director, has a story today about how the accusations may be a first for the county. At the end of the story, which does not have a bylined writer to whom we can give some credit, it says that the law is clear on how to proceed. Though if the defendants enter guilty pleas, they will be sentenced in July. But if any of them enter a not guilty plea, then the case has to be moved to General Sessions Court or to a grand jury. Now, General Sessions is not a court of record. It's not a court where they would be tried by a pettit jury of 12 of their peers. To be tried by a jury of their peers, they would have to be first indicted by the grand jury, the big jury that looks at the overall situation and determines if there is warrant and if a trial is deserved. And then they would be indicted and then to be tried. But it seems to me that entering guilty pleas is not likely. They will want to contest the findings. They will want to show that what they didn't know. They're of course trying to prove a negative, which is perhaps difficult if you're a defendant. But the grand jury is probably their best hope. I would think, from just a sketchy thought about how that works. And have their goodwill, their good intentions, even their seeming negligence viewed by the people, for the people to say, well, indeed, they didn't know, and they are not guilty of negligence in not reporting crimes that were whispered about in the hallways.
Right. You'd have to be knowledgeable about something to be found guilty of failing to report it. I don't know if there's a shooting going on across the street right now, so I can't be charged with criminal negligence if I don't go help the person across the street. It doesn't really work that way. So that's undoubtedly going to be the argument, is I had no way of knowing this was happening. I didn't hear about it until I heard about it, and that's when I reported it. So this is going to be a very interesting case to follow for sure. And now we have sort of a timeline too of how far into the future this is going to proceed. At least July, we're seeing that.
Well, for the charges to stick, Neil Pinkston and his staff have to have some kind of evidence from people who told or who have told investigators that, well, we did send an email or we did speak to so and so on this date, and saying that we had heard of a student being beaten by a pool cue, and who knows what these officials heard. And so the witnesses against them will be pressed to testify that they should have known enough and should have heard enough, at least from individual witnesses, to have gone to authorities to declare a crime has been committed and people need to be removed from their places of authority.
You have to think about the timeline too. We're very soon into the beginning of this. This is a brand new case in terms of the grand scope of how things generally move. This is moving very quickly. Again, it happened, the alleged rape happened on December the 22nd while they were on a retreat in Gatlinburg in Sevier County. And then the treatment happens for the victim soon after that here in Chattanooga UT Medical Center. So there's a very fast moving timeline here. We're not even 2 months into the happenings here. So we're expecting perhaps quite a lot in a very short period of time. And to be fair, we're getting quite a lot in a very short period of time. We're wanting answers. I know the listener wants a lot of answers, especially if you're a parent. You have perhaps a kid who went to Ottawa High School. There's a lot of anger and ill will going on, especially if you look at social media. If you go on Facebook and you just do a search for Ottawa, you're going to see a lot of parents and even a lot of younger people who are very, very angry about the proceedings, about how this is being handled, especially with the Sunshine Law possibly being violated, where the lie about the gag order. That's the thing that a lot of people are very, very upset about, where there was a claim that there's a gag order, we can't talk about this, and then it turns out there was no gag order, but I heard there was a gag order, but there actually wasn't a gag order, but I should have known it wasn't a gag order. So
I think people are just ignorant about how the law works. A judge can issue a gag order, and sometimes he will, but it applies only to the people directly in his jurisdiction. And
in Sevier County.
In Sevier County. So no one on the school board here, no school official, no hireling, no elected person would be bound by that order. He just doesn't have jurisdiction over the people whom he would pretend to be controlling by a gag order. So if he had written a gag order, it would have been only for those in his immediate in that judge's and that court's immediate in personam jurisdiction. In other words, jurisdiction over persons.
It's kind of like the thing in the cartoons where you see, he crossed the county line, we can't get him now. And that's sort of the same mentality. This gag order, if there was one, which there wasn't, in Sevier County, would only apply to Sevier County. The county judge there can't suddenly have the long arm of the law go across several counties into Catoosa or to Hamilton. It doesn't work that way. Even if they were asked not to talk about something, a school board meeting is a matter of public record. A school board meeting is a public affair because it has to be. The parents need to know what's going on in the school system in which they're paying for, even if they're not involved in it.
A crime is something that's notorious. A crime can't be discussed in secret. It can't be tried in secret. That's why we have our listener has rights to an open trial. He has a right to confront his accuser in person and in public.
In persona, yes.
And so crimes, because they're notorious, have to be public, and they have to be noised abroad. There has to be open coverage of hearings. There has to be the right of the press to cover all proceedings that are public. We don't have secret trials. We don't have secret laws in Tennessee. And so a gag order, again, getting back to silencing people, a gag order in Sevier County would have had very limited authority on anyone here. But we all thought, because there was a report, these officials here thought that, again, a guy advised by a lawyer. I think lawyers are a decrepit class of people. Often. They are so decrepit. They say things, and I have seen so many sloppy statements from lawyers who are willing to bend over. They're often willing to bend over backwards where no bending is required. That's what often happens by lawyers who, of course, are concerned about limiting risk, limiting exposure, and limiting liability of people in their care, their clients,
and maximizing how many hours you're working.
Well, I wouldn't say that, but they often don't let people do what their jobs require them to do, and then mitigate the risk. I think that's what we should consider, that public officials should act honorably and publicly according to law, and not be cowed by attorneys issuing opinions that are not based on an actual order binding upon those officials.
So let's sort of recap over what we know so far, what's happening, what the current story is. We've got the situation now where the 3 adults have now been charged. There's the summons for the there's a summons for the 3 adults now to be going to the juvenile court, and they're going to be going there on next Thursday. So that's the latest that we know so far. That's the very latest bleeding edge of the news, is that 3 adults are going to be going to juvenile court in order to face the judge. And that's the latest that we know so far. So 3 adults, one of which is the coach, another one's the assistant coach, and the other one is a director of the athletic system, the director of the athletic teams. So we have now 3 adults who are charged. And again, to bring you up to date, we have several juveniles who are also charged. But then the perhaps the biggest news that we have that's breaking is that there may have been 4 victims. Now, I keep seeing that 4 victims thing where they're saying that they were beaten with pool cues. That's the claim. We have 4 victims beaten by pool cues. Was the one victim whom we keep hearing about included in that number of 4? Were there 5 victims total, or are there 4 and one got it worse than the others?
Russell, I would suggest that number applies to the total, including the one who was sodomized. Were the others just beaten? I don't know. It seems like the word beating, pool cue beating, is sort of vague, and it could cover a host of sins.
Right. So we have now, that's the very latest on it. We have 3 adults who are charged. We have the juveniles who are already out on bond. At least some of them are out on bond already. And then you have the problem now with the victim who is now out of the hospital, but is in quite a bit of psychological trauma. If the statements from the victim family are to be believed, that he's in a significant amount of trauma. Although he can eat again, we heard about that. He does have his appetite back, but he's uncomfortable being alone. And he still has pretty severe nightmares from his significant trauma, which he experienced.
The story is of special interest on account of the scale and the number of people affected. If this were a private school, you would still have a scandal. You still might have a crime, but everyone has a stake in it because this is a taxpayer-funded school. Everyone has a sense of ownership about it. This is not just not a private school, but it is public, and so you have many people interested. Somehow we all take possession of it since it's our school system, right? We all own it ostensibly through being taxpayers and being residents here. But what I've noticed in reading about this story and hearing our reports and reading coverage here in Chattanooga is that there's what I call a scale problem. You have a giant system that's not responsive to people. It's controlled by Nashville. It's controlled by laws, and everyone is sort of bound to respond to others. In other words, not to parents who have real say, but to laws and boards and regulatory agencies and the Board of Education in Nashville. I guess it's on Dedrick Street, and so there's anger that there's not as much approachability and responsibility as people would like. They don't have it. They really don't have it. And so the court is now going to bring order, and administration is going to write some more lines of type, which are going to describe what the statute requires. And there's I think a great deal of alienation among the patrons of schools, that is to say local parents, and among them and the board and the state officials.
We're going to keep you updated on this as it is a developing story. It's going to continue developing for quite some time now, we can expect. This is AM 1240 Hot News Talk Radio. We're always on at hotnewstalkradio.com. Thank you, David Tulis, for joining me. And you're always on the David Tulis Show every weekday. What time is that?
Every morning, 9 to 11. Thank you, Russell.
9 to 11 right here on Hot News Talk Radio. You can also get that on the TuneIn Radio app for your smartphone. Just get the TuneIn Radio app and then search for Hot News Talk Radio. You can listen to us streaming live. Normally, this would be binary. We had to do a special report because special events are going on. It's going on in the Tennessee Valley. It's going on Hot News Talk Radio.
Seconds. We'll give you Chattanooga and the world. WSDG.